the first knock didn't sound like a knock. It sounded like the side of my house being tested for weakness. I was awake because I'd been awake for days, sleeping in short bursts on the couch in the front room where I could see the driveway through the blinds. The clock on the microwave read 4:52 a.m. The security light outside was still on, washing the frost in a hard white glare. The second knock came with a voice. "Police department, come to the door." I didn't move right away. I sat up slowly, listening, boots on gravel, the faint whine of an idling engine. "More than one, sir." The voice said again, louder, "Come to the door now." I stood and went to the window by the front door, keeping my head low. Through a gap in the blinds, I saw 2 patrol cars angled at the curb, light bars off but running lights on. A third vehicle sat behind them with a spotlight mounted near the mirror. A deputy's SUV. The beam was pointed at my front steps. 3 officers were visible. 2 more were further out, standing near my mailbox and the neighbor's hedge. One had a long gun held across his chest, muzzle down, stance practiced. I felt the edge of something cold settle behind my ribs. Not fear in the usual sense, more like recognition that a process had started without me, and I was already behind. I didn't open the door. I spoke through it. "Can I help you?" The voice answered immediately, formal. "James Carter." "Yes." "Open the door. Keep your hands where we can see them." "Do you have a warrant?" A pause. Then paper against wood, as if someone was holding a folder close. "We have a court order. Open the door." A court order at 4:52 a.m. before sunrise. I looked down at my phone on the coffee table. No missed calls. No voicemail notifications. I had service. I also had the sense that calling anyone would do nothing, because whatever this was, it was already written and filed and signed. I unlatched the chain but left it on, opened the door a few inches. Cold air pushed in sharp and clean. The nearest officer stepped forward enough for his badge to catch the light. He was calm, not aggressive, but his eyes stayed on my hands like they were objects that could change shape. "Mr. Carter," he said, "we're serving you with an emergency protective order and a civil standby notice. You need to step outside." "Emergency protective order for who?" "Evan Carter." My brother's name sat in the air longer than it should have. Evan lived 2 states away. Evan didn't wake up early unless there was money attached to the morning. The officer continued reading from the paper. "This order requires you to have no contact with Evan Carter and to surrender any firearms in your possession pending further hearing. We are here to keep the peace while Mr. Carter retrieves personal property from the residence." "I don't have his property." The officer's expression didn't change, but his tone hardened slightly, the way it does when someone believes we're about to argue facts with paperwork. "Sir, he is listed as a protected party and the order is active. I need you to step outside, hands visible. Do you have any weapons in the home?" "No." "Any firearms registered to you?" "Yes." "How many?" "2." He nodded as if the answer was expected. "We will need to secure them temporarily. Do not go back inside once you step out unless instructed." Behind him, in the dark near the curb, I saw movement. A figure got out of a vehicle I hadn't noticed at first, parked further down with lights off. A black sedan. The figure wore a jacket with the collar up. He walked toward the cluster of officers like someone arriving at a meeting. Even in low light, I recognized the way he carried himself. Slight forward lean, hands moving more than necessary. Evans stopped near the deputy's SUV and spoke to someone I couldn't hear. He didn't look at the house, not yet. The officer held the papers closer to the crack in the door. "Sir, this is a lawful order. If you don't comply, you may be arrested." I opened the door fully and stepped onto the porch. I kept my hands visible at chest height, palms out like someone surrendering without drama. The cold hit the inside of my nose. The sky was a dull grey, not yet light, but the neighborhood was already awake because police presence has a way of waking houses that aren't even involved. The deputy approached and positioned himself slightly behind the patrol officer, angled toward my left side. Not threatening, just controlling space. The patrol officer asked me to confirm my date of birth. I did. He asked if I had been served with any court documents relating to my grandfather's estate. I said yes. He asked if I had threatened my brother in the past 48 hours. I said no. He didn't argue, he just nodded, made a note on the margin of the form. Evan finally looked at me. He lifted his chin slightly, the kind of gesture people use when they think they're being restrained from saying something. He kept his hands in his pockets. I didn't speak to him. The officer had already told me not to. The deputy spoke now, voice lower, more procedural. "Mr. Carter, we're here for a civil standby. Your brother will be collecting items he claims belong to him. If there's a dispute, we don't adjudicate it here. He gets what's in the order, and any property disagreements go back to court." "What items are listed?" I asked. The deputy glanced at the paper and read without looking up. "Documents related to the estate of Harold Carter. Keys, a safe deposit box key, a thumb drive, any original trust documents in your possession." My grandfather's name, Harold Carter, spoken by a deputy at my porch before sunrise, hit differently than it should have. The estate was the reason Evan was here. It wasn't the reason he gave the police, but it was the reason he existed in my driveway at 4:52 a.m. I kept my voice even. "Those aren't his. Those belong to the trustee. I'm the trustee." Evan smiled slightly, just enough to register. He looked past me into the house, as if scanning for where I kept the paper. The patrol officer said, "Sir, there is a hearing set for 9:30 this morning at the county courthouse. That's on the order. Until then, this stands." I turned my head toward Evan, but I didn't address him. I addressed the officer because the officer was the only one in the situation who didn't have a personal stake. "Why is this being served at my house?" I asked. "He lives in Ohio." The officer's eyes flicked toward the deputy, then back to me. "He filed here because you reside here and he alleges the threats occurred here. We're not here to debate that on the porch," the deputy added. "We also have information that you may be in possession of documents relevant to an ongoing investigation regarding financial exploitation of an elder. That's not a criminal charge at this moment. It's information provided in support of the petition." The phrase financial exploitation of an elder wasn't random. It was built for impact. It was designed to turn a family dispute into something that makes police feel obligated to be present. "My grandfather had been dead for 11 days. I said, "My grandfather's attorney has the originals." Evan's smile disappeared. He looked at the deputy quickly, like that detail wasn't supposed to come up yet. The deputy asked, "Who's the attorney?" "Marianne Lowe." "Lowe and Pierce. She drafted the trust. She witnessed the last amendment." Evan's jaw tightened. The first real sign of strain, the deputy made a note. "Do you consent to us entering to secure firearms and to allow your brother to retrieve the listed property?" I did not consent to anything, but I also understood the difference between refusing and making the situation worse. There were too many moving parts, and none of them were mine. "I will comply with the order," I said, "but I want everything documented. I want body camera footage preserved." The patrol officer's face shifted slightly. Not annoyance, something like respect that I was speaking the language of records instead of anger. "Understood," he said. "We have body cameras on. We'll document property removed." Evan stepped forward then, enough to be included in the light. "I just want what's mine," he said. It wasn't a plea. It was a performance for the uniforms. I didn't respond. The deputy told me to remain on the porch while the officer accompanied me inside to retrieve the firearms. He entered first, slow, scanning corners like he'd done it before. I walked ahead with my hands visible and moved toward the hall closet where I kept the locked case. I gave him the key. He opened it. He photographed the serial numbers with his phone, then wrote them down. He asked if there was ammunition. I told him where, and he secured it too. While he worked, I heard voices outside. Evan's voice low and fast, the deputy's voice slower. Then footsteps, more than 2. Evan entered the house with the deputy behind him, staying within a few feet like a handler. Evan moved straight toward my study, not my living room, not my kitchen, not anywhere that would contain personal property. He went for the paper. He stopped in the doorway and looked at me, finally making direct eye contact like we were alone. "This didn't have to be like this," he said. I looked at the deputy. "Is he allowed to speak to me?" I asked. The deputy said, not directly. Evan, don't talk to him. Evan lifted his hand slightly, palms out, as if he was trying to show how reasonable he was. I'm not trying to, he said. But he was. He walked into my study and opened the bottom drawer of the filing cabinet without asking. He knew which drawer. That was the first thing that made everything else click into place. He had been here before, not physically, but through someone's description. He knew the layout of my records. He pulled out the folder marked Carter Trust. The label was typed in all caps. He held it like he'd just found stolen goods. The deputy said, "That the documents?" Evan nodded. "That's the trust," he said. "He's been hiding it." I kept my voice measured. "That is a copy. The original is with the attorney. That folder contains the trustee acceptance, the bank letters, and the inventory draft." Evan didn't react to the word copy. He didn't have to. He wasn't there to learn facts. He was there to take physical control of anything that might delay him. He flipped the folder open and looked for something specific. His fingers moved fast, practiced. He wasn't reading, he was hunting. Then he pulled out a smaller envelope from inside the folder. A plain white envelope with a return address I recognized immediately. Lowe and Pierce, P.A. My stomach tightened slightly, not from fear, but from surprise. That envelope shouldn't have been in my study. Evan held it up to the deputy. "This is from the law office," he said. "He's got the originals." "It's sealed," I said. "It came certified. I haven't opened it. It's addressed to me as trustee." Evan's eyes narrowed in a way that revealed the actual goal. He didn't care if it was sealed. He cared that it existed. A sealed envelope meant an attorney record trail. The deputy asked, "What's in it?" "I don't know," I said truthfully. "It arrived yesterday afternoon. I was going to take it to the bank this morning." Evan looked at the deputy, then at the patrol officer holding my firearms case. "He's lying," Evan said. "He's been intercepting everything. Grandpa was confused and he took advantage. I have a statement from the nursing staff." The words were designed to be believable. They contained an institution, a vague authority, and a moral charge. Nursing staff. Confused. Took advantage. My grandfather had not been in a nursing home. He had been in a rehab unit for 6 days after a fall, then discharged home. Evan hadn't visited once. The deputy said, "We're not deciding that here. The hearing is this morning." Evan nodded as if he agreed, then looked at me with something like quiet contempt. "Their shoe won't mind if I take these," he said, and he slid the sealed envelope into his jacket pocket. "Deputy," I said immediately, "that's addressed to me. It's legal mail." The deputy stepped forward, hand raised. "Evan, the order lists estate documents, but not mail addressed to him. Take the folder, but give the sealed envelope back." Evan froze. His eyes went to the deputy's face, calculating. Then he pulled the envelope out slowly and handed it back without speaking. That moment was the first crack, the first time the uniform questioned him in front of me. It wasn't victory. It was a signal that procedure still mattered, even at 5,000 to 5 a.m. on a porch. Evan collected the folder anyway. He also took my grandfather's house keys from the hook by the back door, claiming they were family property. The deputy allowed it because keys were listed. I didn't argue on the spot. I watched what he took, and I watched the deputy write it down. When they were done, the patrol officer returned the firearms case to his car. The deputy handed me a copy of the emergency protective order. My name was printed in the respondent box, Evan's name in the protected party box. The allegations were typed short and sharp. Respondent threatened protected party with violence over inheritance dispute. Respondent possesses firearms. Protected party fears for safety. The hearing notice was printed near the bottom. 9:30 a.m., same day. County Courthouse. Evan stood behind the deputy while I read, face blank. He had the look of someone who'd rehearsed the expression. I looked up at the deputy. "Who signed this?" I asked. He pointed to the name. A magistrate I recognized. Same one who handled overnight orders. "Do I have to leave my house?" I asked. "Not unless it says so," he replied. This one is no contact, firearms surrendered, and civil standby for property retrieval. You can stay. He's required to stay away from you, but he can still file in probate. Evan spoke again, careful, for the record. I'm just trying to protect Grandpa's wishes, he said. I didn't answer. They left in a line of vehicles, lights still off. Evan's sedan followed last, disappearing into the grey. When the last engine noise faded, the neighborhood returned to stillness like nothing happened. Frost. Silence. The faint hum of my refrigerator inside. I went back into my house and locked the door. Then I placed the protective order on my kitchen table and read it again, slower. The most important part was not the accusation. The accusation was what got the paper signed. The important part was the case number. With a case number, Evan had entered a formal system that ran on files, timestamps, and signatures. That meant he was no longer just lying to family. He was lying to courts. I made coffee. I didn't drink. I opened my laptop and logged into the county clerk portal. The protective order case number showed as filed at 2014 a.m. Petition for protection from abuse. Filing party, Evan Carter. Respondent, James Carter. I clicked the attachments. There were 3. Petition. Affidavit. Exhibit A. The exhibit was a screenshot of a text message thread. My name at the top, Evan's name beneath. The thread showed me writing, "If you come here and try to take anything, I'll handle you myself. I'm done being nice." Below it, Evan wrote, "Are you threatening me?" Then my name again. You'll see. I stared at the screen. My number. My name. The thread looked correct. The timestamps were from 2 nights ago, at 11:47 p.m. I hadn't sent those messages. I didn't need to argue with my feelings about it. I knew the facts. My phone was in my hand. I opened my text history with Evan. There was nothing from 2 nights ago. The last message from him was 3 weeks earlier. Call me. It's about Grandpa. My last reply, I'll call tomorrow. I took screenshots of the real thread and saved them to a folder labeled 2026-2-20 herring. Then I scrolled further down the petition and saw something else. In his affidavit, Evan claimed Grandpa had executed a new will 8 days before his death, leaving everything to Evan and naming Evan as executor, and that I had seized the will and trust documents and was attempting to unlawfully assume trustee powers. That wasn't just a protective order play. That was the core move. If he could frame me as a threat and a thief, he could justify emergency relief and probate. He could get temporary authority before I could respond, and then he could act fast with banks and property. Time pressure wasn't an accident. The hearing at 9:30 a.m. wasn't about Evan feeling unsafe. It was about Evan getting in front of a judge before the banks opened and before my attorney could intervene. I looked at the clock. 5:28 a.m. I called Marianne Lowe's office. It went to voicemail as expected. I didn't leave a message yet. I wrote down the facts first, because emotion on voicemail wastes minutes. At 5:31 a.m., I called the after-hours number Marianne had given me when Grandpa first fell. A receptionist service answered. I asked them to page her for an emergency probate matter. While I waited, I opened a locked drawer in my kitchen and removed the sealed Lowe and Pierce envelope Evan had tried to take. It was still sealed because I had a habit Grandpa taught me. Don't open legal mail when you're tired. Fatigue makes people sloppy with documents. I slit it open carefully with a letter opener and pulled out the contents. Inside was a letter on firm letterhead and a single-page document. The letter was dated yesterday. It said in restrained legal language that the firm was transmitting a certified copy of the original trust instrument, including the final amendment executed on January 12. It also said explicitly that the original instrument remained in the firm's vault, and that any purported later will or amendment not executed in accordance with the trust's amendment provisions would be invalid. Attached was the single page, Trustee Acceptance and Certification. It identified me as successor trustee upon Harold Carter's death. It stated that my grandfather's revocable trust became irrevocable at death, and that as trustee I had authority to marshal assets, secure property, and communicate with financial institutions. It was signed by Marianne and notarized. At the bottom was a line that mattered more than anything else. In the event any party produces an alternate instrument dated after January 12, the firm retains the original execution video, notary journal entry, and witness affidavits. Execution video, notary journal, witness affidavits. My grandfather had planned for this, not because he expected his grandson to become a thief, but because he understood human behavior when money changes hands. He had grown up during the kind of poverty that taught people to respect paperwork. I stared at the phrase execution video and felt something settle into place. Evan could file whatever he wanted at 2014 a.m. He could fabricate texts. He could cry to a magistrate. But he couldn't erase a law firm's vault. At 5:38 a.m., my phone rang. Marian Lowe. Her voice was alert, not groggy. James, she said. I got the page. What happened? I didn't start with Evan's lies. I started with the process. I was served an emergency protective order at 4:52 a.m. Evan filed at 2014. He alleges threats, firearms, and claims Grandpa executed a new will 8 days before death, leaving everything to him. They did a civil standby. He took my trust folder copy, but not the sealed mail. Hearing is at 9:30. There was a silence, controlled. Then she said, "Did he take anything with my firm's originals?" "No." "Good," she replied. "He can't. He doesn't have access. I anticipated he'd attempt something like this." "I saw the affidavit," I said. "He attached fake text messages." "Save everything," she said. "Do not contact him. We will appear at the hearing. I'm calling our litigation partner now. Also, you need to secure Grandpa's house immediately. Change locks if you can do it without violating the order." "He took the keys," I said. "I'm aware," she said. "Keys don't matter. We'll address that." "Do you have doorbell camera footage of the officers and of him removing property?" "Yes," I said. "It's cloud stored." "Export it," she said. "Also pull your cellular provider logs for the time of the alleged texts. We need objective records. I'll meet you at the courthouse at 9:00. Bring the protective order, bring your phone, and bring the letter I sent. Do not open any more mail. Do not talk to neighbors. Do not post online. Keep it clean." Her directives were practical. That was what I needed. After I hung up, I sat at my kitchen table and did what I always do when the world tries to turn chaotic. I built a file. I labeled a folder. 2026-02220 Carter hearings. Inside it, I saved the Clark portal downloads, petition, affidavit, Exhibit A. I saved screenshots of my real text thread. I saved a screenshot of my phone showing no messages from that time. Then I logged into my doorbell camera account. The clip from 4:51 a.m. showed the deputy's SUV pulling up. The clip from 5:06 a.m. showed Evan leaving with the trust folder. The deputy wrote down what he removed. I could see the paper. I could see his handwriting. I could see Evan's pocket when he tried to slide the sealed envelope in. It wasn't dramatic footage. It was procedural. It showed that I complied and that the deputy corrected Evan. It showed the power dynamic, not anger, but control. I exported those clips. At 6:12 a.m., I drove to my office downtown. I run a small engineering firm. It's mostly contracts and compliance work. The office had a printer that could produce clean copies and a scanner that could timestamp. Also, it was a place where Evan couldn't show up with a deputy and claim civil standby again. On the way, I called my cellular provider. I didn't ask for an opinion. I asked for a record. "I need call and message logs for my number," I said, specifically for February 18th between 11:30 p.m. and midnight. I need to know whether SMS messages were sent to Evan Carter's number during that period. This is for a court hearing this morning. The representative said logs weren't instant. I asked for an expedited request and a case number. I got one. I also turned on my phone's screen time and security logs and took screenshots of my account showing no new devices had logged in. It wasn't perfect evidence, but it was another layer. At 7:04 a.m., Marianne texted me. "Bring everything. We have filings." Meet 9. At 7:30 a.m., My assistant arrived and looked at my face long enough to realize something was wrong. I didn't tell her details. I asked her to print out the trust certification and the low letter, 3 copies. I asked her to print out Evan's affidavit and exhibit. I asked her to print the doorbell camera, still frames with timestamps visible. Then I asked her to pull my calendar logs from the last week. Meetings, calls, any record showing I had been at home and at work. Not because it proved innocence, but because in court, chronology matters. At 18:10 a.m., my phone buzzed with a bank notification. It wasn't from my account. It was from my grandfather's estate account that I'd been added to as trustee last week at First County Bank. The message read, "Alert, new user access request. Call if unauthorized." My breath stayed steady, my mind didn't. Evan was already moving. I called the number in the alert. The bank's fraud line answered. "I'm the successor trustee of the Harold Carter Revocable Trust," I said. "I received an unauthorized access request alert. I need a hold placed on all changes pending verification." The bank asked me to verify my identity. I did. Then the representative said something precise that told me Evan wasn't guessing. "The access request is from Evan Carter," she said, claiming he is the executor and providing documentation. "What documentation?" I asked. "A will and letters of authority," she said. "He doesn't have those," I replied. "Any letters would be fraudulent. The trust controls the accounts." "I understand," she said, "but we need documentation from you to place a hold." "I have trustee certification and counsel," I said. "I have an emergency hearing in 45 minutes. I need the hold now. This is an active family fraud attempt." She hesitated, then said, "We can place a temporary restriction if you email the trustee certification immediately." I emailed it while on the phone. She confirmed receipt. She placed a hold. "You should come to a branch today," she said. "Preferably with your attorney." "I will," I said. At 8:35 a.m., as I drove toward the courthouse, my phone rang again. This time it was a number I didn't recognize. Local. I answered cautiously. "James Carter?" a man asked. "Yes. This is Detective Moran with the County Sheriff's Office. I'm calling regarding a report filed by Evan Carter alleging financial exploitation of an elder and threats. I understand there's a protective order hearing this morning." "Yes," I said. "Do you have counsel?" he asked. "Yes." "Good," he said. "I'm not interviewing you over the phone. I want you to know I reviewed the petition briefly. There are some inconsistencies. Bring any documentation you have to the courthouse. I may be present." "Inconsistencies like what?" I asked. "Like timelines," he said. "And like the fact that your brother filed threats while also filing probate pleadings to become executor within the same window. It looks like leverage. I'll see you there." He hung up. That phone call shifted the temperature. It meant the sheriff's office wasn't treating Evan as a victim automatically. It meant someone was reading beyond the dramatic words and looking at motive and sequence. At 8:58 a.m., I met Marianne in the courthouse hallway outside courtroom 3B. She was in a dark coat, hair pulled back, folder in hand. Beside her was a second attorney I hadn't met, a man with a flat expression and a thin briefcase. "This is Alan Pierce," Marianne said. "Litigation." We didn't shake hands like it mattered. We exchanged files. Marianne reviewed the protective order copy and the petition, her eyes moving quickly. "He used a text fabrication," she said quietly. "Crude. Also, he claims Grandpa executed a new will 8 days before death. 8 days before death, Grandpa was in rehab with limited visitors. I have the facility logs." "Execution video," I said. She nodded once. "And a notary journal, and witness statements. We'll use those if he produces anything." The courtroom doors opened at 9:15. People filed in for various matters. When our case was called, we moved forward. Evan sat on the opposite side with a lawyer I didn't recognize. The lawyer looked like someone Evan had hired, fast, clean suit, thin file, a face that said he'd been paid for speed, not loyalty. Evan looked at me without expression. The controlled posture he'd used in my driveway had been replaced by a subtle confidence. He thought the paper was already doing his work. The magistrate from the overnight order sat at the bench, now acting in a daytime docket. The clerk called the case. Evans stood. His attorney spoke. Your Honor, Mr. Duck, Carter seeks continuation of the protective order and immediate relief to prevent his brother from dissipating estate assets. There is an ongoing probate dispute. Our client has credible fear based on threats received by text message and the respondent's possession of firearms. Marianne stood when it was our turn. Your Honor, we ask that the emergency order be dissolved immediately. The text messages attached are fabricated. Additionally, the petitioner is using this court as leverage in a probate and trust dispute. Mr. Carter is the duly certified successor trustee of the controlling trust instrument. We have counsel of record and documentary evidence. The magistrate looked tired but attentive. She had seen this type of case before. Family conflicts dressed in protection language. She addressed Evan. Mr. Carter, she said, you filed this at 2014 a.m. Explain why it was necessary overnight. Evan spoke directly, keeping his tone measured. I didn't feel safe, he said. He's been holding documents and he told me if I tried to take anything, he'd handle me. He has guns. I've been trying to do this right, the magistrate asked. Where do you reside? Ohio, Evans said. And you came here overnight? Yes, Evans said. I drove. Marianne stepped in. Your Honor, he came here overnight to seize documents and to attempt bank access. We have a bank alert from this morning showing he attempted to add himself as account authority using purported letters. The magistrate's eyes moved to the clerk, then back to Evan. Is that true? She asked. Evan's attorney spoke quickly. Your Honor, the petitioner is the rightful executor under a later will. He has an obligation to secure assets. Marianne's partner, Alan, opened his briefcase and pulled out a single sheet. Your Honor, he said, we're not in probate court today, but this protective order is being used to gain possession of estate instruments. Mr. Det, Carter's law firm retains the original trust instrument and has execution video and notary records. The petitioner's claim of a later will is unsubstantiated and, given the facility logs, likely false. The magistrate held up a hand. Keep it narrow, she said. This is a protective order hearing, but motive matters. She turned back to Evan. Mr. Carter, did you file any other actions today? Evan hesitated. The hesitation was short, but it existed. His attorney answered, we have a probate petition filed to open an estate and appoint the petitioner as personal representative. The magistrate looked at him. So you filed a protective order and a probate petition in the same early morning hours, she said. Yes, Evan's attorney replied, because time is of the essence. Marianne asked permission to approach and handed the magistrate a copy of the trustee's certification and the law firm letter. The magistrate reviewed them briefly. These documents identified James Carter as successor trustee, she said. Yes, Marianne replied, and the trust controls the assets. Probate is limited. Evan is attempting to bypass trust controls. The magistrate turned to me for the first time. Mr. Carter, she said, did you send the text shown in Exhibit A? No, I said. Those texts are not in my phone. My phone records will show no messages sent at that time. Evan's attorney leaned forward. Your Honor, the petitioner has screenshots. The respondent could have deleted them. Alan Pierce spoke, controlled. Your Honor, screenshots without carrier records are weak, and we can show a pattern. He alleged threats to obtain a civil standby at dawn to seize trust documents. The deputy on scene corrected him when he attempted to take sealed legal mail addressed to my client. We have body camera and doorbell footage. The magistrate looked down at the petition again, then at Evan. Mr. Carter, she said, did you attempt to take sealed mail addressed to your brother during the civil standby? Evan's face stayed still. He made a small movement with his jaw. I was retrieving documents, he said. I didn't know it was sealed. The magistrate's eyes narrowed slightly. You knew enough to claim originals in your affidavit, she said, but you didn't know it was sealed. She looked at the deputy seated at the back of the room, present as a witness for service. He stood when she called him. Deputy, she asked, Did the petitioner attempt to take sealed mail addressed to the respondent? The deputy answered without emotion. Yes, ma'am, he said. I instructed him to return it. He complied. Did the respondent resist service or act aggressively? She asked. No, the deputy said. He complied. He asked for documentation. He requested body camera preservation. The magistrate nodded once. That was enough. She turned back to Evan. Mr. Carter, she said, this court does not issue protective orders as tools in estate disputes. You reside out of state. You drove in overnight, filed a petition, and immediately used it to retrieve estate documents. The evidence of threat is currently uncorroborated beyond screenshots. Evan's attorney began to speak. She raised her hand again. I am dissolving the emergency order, she said. No further protective order will issue today. Any disputes regarding the estate and trust proceed in probate court. Respondent's firearm shall be returned upon completion of administrative process. Further, I'm referring this matter to the sheriff's office for review regarding possible false statements in a sworn filing. Evan's face changed then. Not anger, something like a sudden loss of internal math. The magistrate finished, still measured. You are ordered to return any documents removed from respondent's home that are not your personal property. Failure to do so will be considered in any future proceedings. She looked at me. Mr. Carter, she said, you will have no contact with your brother except through counsel. Understood? Yes, I said. She struck the file with her pen lightly, signaling the end. The clerk called the next case. We stepped back into the hallway. Evan moved toward the exit quickly with his attorney. Marianne didn't follow him physically. She followed him procedurally. James, she said, we go to the bank now. Then we go to probate court and file our response before noon. Before noon. The time pressure didn't stop because one paper dissolved. Evan still had filings. As we walked, Detective Moran approached from the far end of the hallway. He nodded at Marianne, then at me. I heard, he said quietly. I'm going to want those screenshots and your doorbell exports. Also your brother's affidavit as a sworn statement. Marianne handed him a business card. Send requests through counsel, she said. We'll cooperate. He nodded. Off the record, he said. We see this when money is involved. But he got a deputy to your house at 5 a.m. That's a misuse of process. We'll look at it. At 10:12 a.m., we were at First County Bank in a small conference room. The branch manager and a compliance officer sat across from us. Evan was not there, but his attempt had already left footprints. The compliance officer placed a folder on the table. This morning at 8,007, she said, Mr. Evan Carter came to our East Side branch with documents claiming he was executor. He requested access to the trust account and to the safe deposit box registered to Harold Carter. Did you grant it? Marianne asked. No, the compliance officer said. We require verification. We flagged it due to conflicting trustee certification on file, but he did attempt. She slid a copy of what Evan provided across the table. It was a will, or something formatted like one, dated 8 days before Grandpa died. It left all property, real and personal, to Evan. It appointed Evan executor. It had signatures. Marianne glanced at it and didn't react emotionally. She reacted like a technician seeing a flawed schematic. That signature is not consistent, she said. I looked at it too. Grandpa's signature had always been clean and slightly angled, the last name underlined with an old habit. On this page, the signature was heavy, the underline missing, the pen pressure uneven. It looked like someone trying to imitate motion, not someone writing naturally. The compliance officer continued. He also produced letters purportedly from a county clerk appointing him personal representative. Alan Pierce picked those up and smiled once without humor. These are not official letters, he said. The seal is wrong. The format is wrong. There is no order without a judge's signature. This is fabrication. The compliance officer nodded. We thought so, she said. That's why we did not grant access. She pointed to a printed system log. Our system recorded his request, his ID scan, and the time. We also have camera footage, records, timing. Authority. Marianne slid our trustee certification across to them again, along with a letter instructing the bank to restrict changes pending court confirmation. The branch manager said, "We can lock the safe deposit box access to trustee only with dual verification." "Do it," Marianne said, "and document his attempt in a formal incident report." They agreed. At 10:58 a.m., we drove to Grandpa's house. It was a small ranch-style home on a quiet street, paid off years ago, the kind of place Evan used to visit when he was a teenager and needed cash for something he didn't want to explain. Grandpa had always given it, always quietly, always with the expectation that family handled family business without involving outsiders. Now outsiders were the only reason Evan wasn't inside the house emptying drawers. When we arrived, the front door was locked. But the deadbolt had scratch marks around the frame. Someone had tried the key too aggressively. Marianne didn't enter. She didn't have to. She called a locksmith while standing on the porch and showed him her trustee certification when he arrived. By 11:34 a.m., the locks were changed. New keys were cut. The locksmith wrote the invoice to Harold Carter Trust, James Carter, trustee. I photographed the invoice. I kept the receipt in the file. At 11:50 a.m., as we stood in Grandpa's living room, my phone buzzed again. An email alert from the county clerk portal. New filing in probate case. Emergency motion for temporary appointment. Files by Evan. He was still trying to move faster than we could. Marianne didn't look surprised. She looked slightly relieved, as if Evan's predictability simplified strategy. "We file our objection now," she said, "and we attach the magistrate's referral and the bank incident report." We returned to her office. Alan Pierce drafted a response while Marianne called the rehab facility. At 12:40 p.m., Marianne placed a printed facility log in front of me. "This is the rehab unit visitor log for the week Evan claims the will was executed," she said. "Visitor entries require ID. Evan is not on it. You are." "I am, once, as legal counsel. The notary Evan claims witnessed this will is not a staff notary." She placed another paper beside it. "This is the notary registry for the notary stamp on Evan's will," she said. "The commission expired last year." Expired commission. That wasn't a small procedural flaw, that was fatal. Evan's will wasn't merely questionable, it was structurally defective. At 1:15 p.m., Detective Moran called Marianne, not me. She put him on speaker with my consent. "We ran the number in Evan's exhibit," Moran said. "The screenshots he attached show they came from an iPhone interface, but the metadata from the PDF upload suggests it was generated on a desktop application. We're pulling his device history via warrant request, but the judge will want more." Marianne replied, "We have carrier request pending for James. We also have the doorbell footage showing Evan's intent to take sealed legal mail. We have the bank's copy of the fabricated clerk letters." Moran said, "Good." Also, the clerk confirmed, "No appointment has been issued in probate. Evan's letters are fake." Silence followed that statement. It wasn't dramatic, it was the quiet of a line being crossed from civil dispute into criminal territory. At 2005 p.m., Evan's attorney emailed Marianne a demand letter. It was short and aggressive. It demanded we cease interfering with Evan's lawful administration of the estate and threatened to file for sanctions. Marianne responded with one paragraph and 3 attachments: the dissolved protective order ruling, the bank incident report summary, and the notary commission expiration printout. No accusations, no insults, just records. At 3:22 p.m., Evan called me from an unknown number. The protective order was dissolved, but Marianne's instruction remained: no contact except through counsel. I didn't answer. I forwarded the call log to Marianne. At 4:10 p.m., Detective Moran emailed a request through Marianne for the doorbell exports. We sent them. We also sent a copy of the will Evan presented to the bank, the fake clerk letters, and the notary registry showing expiration. At 5:30 p.m., the county prosecutor's office issued a notice of investigation regarding false sworn statements and attempted financial exploitation. It wasn't an arrest. It wasn't a headline. It was the beginning of a different kind of timeline, one Evan couldn't control by driving overnight. 2 days later, a probate judge held the first real hearing on Evan's emergency motion. This judge was not the overnight magistrate. This judge sat in a courtroom where papers were read slowly and claims were tested against foundational rules. Evan appeared again with his attorney. This time he looked less confident. He looked like someone who had been told a story about how the system works and was realizing the story was incomplete. Marianne presented the trustee certification, the law firm letter, the rehab visitor logs, and the bank incident report. Alan Pierce presented the notary commission record and the clerk's affidavit that no letters of appointment had been issued. Evan's attorney attempted to argue that Grandpa intended the later will to override the trust. The judge responded with a sentence that ended that line of argument without drama. Intent is proven through valid execution, she said, not through paper that fails basic statutory requirements. The judge denied Evan's motion for temporary appointment. She recognized me as trustee for trust assets and required any probate administration to proceed with notice, not emergency seizure. She also ordered Evan to return all documents removed from my home under the dissolve protective order and prohibited him from contacting the bank or attempting access without court authorization. When the hearing ended, Evan didn't look at me. He looked at Marianne's folder like it was an object that had defeated him. Outside the courthouse, Detective Moran approached Evan and his attorney. The conversation was quiet. I couldn't hear it. But I saw Evan's shoulders stiffen and his head tilt down slightly, the way people react when they're told the conversation is no longer optional. That afternoon, Evan returned the trust folder copy to Marianne's office, not to me. He didn't include an apology note. He didn't include anything personal. He included only what he could no longer keep without increasing his exposure. The firearms were returned to me after administrative processing, documented with a receipt. The sheriff's office closed out the protective order file as dissolved and flagged the petition for review. Over the next month, the estate work continued the way it should have from the beginning: appraisals, bank inventory, creditor notices, property maintenance, and quiet accounting. It wasn't satisfying work. It was necessary work. The most telling moment came later, when Marianne showed me a copy of the execution video still framed from Grandpa's trust amendment. Grandpa sat at Marianne's conference table, shoulders squared, eyes clear. He wasn't confused. He wasn't manipulated. He looked like a man doing what he needed to do to keep his affairs from becoming a fight after he was gone. He had also signed an additional document that I hadn't known about until then, kept in the firm's vault. A statement of intent. It was one page, simple language, signed and notarized. It said he loved both grandsons, but that he was leaving the house and the bulk of the financial assets in trust for me to manage, because I lived nearby, I handled his care, and I had shown consistent responsibility. It said Evan would receive a specific distribution, but not control, because Evan had previously attempted to borrow money without repayment and had pressured him to change beneficiaries. It concluded with one line that felt like Grandpa speaking from the page without raising his voice. If anyone challenges this, let the record speak. Do not argue for me. That line was why I didn't feel the need to win by shouting. Grandpa had already structured the win. He had built it out of timestamps, witnesses, and vault storage. Evan eventually took a plea on a reduced charge related to the fabricated clerk letters and the false sworn statement. The condition included restitution for bank investigation costs and the prohibition against acting as fiduciary for any family estate for a period of years. It wasn't harsh, it was accurate. The system measured what he did and responded in a way that created a record others could rely on. I didn't tell the neighbors details. I didn't give interviews. I didn't write a social post about betrayal. I kept copies of everything and moved forward with the work Grandpa expected. Sometimes people ask me what it felt like to have police around my house before sunrise because of my own brother. The answer is that it felt like paperwork moving faster than truth for a few hours. It felt like being temporarily cast as the problem because someone else used official language. But it also showed me something simple. When you don't chase the conflict and you don't chase the emotion, you can stay close to the only thing that holds in a fight like this: records, logs, signatures, video, bank incident reports, visitor sheets, notary commissions. Those things don't care who tells the better story. They care who can prove it. If you've been through a family dispute that turned into something official, you already know how isolating it can feel when the system shows up at your door first and asks questions later. If there's a detail you want to share or a question about how to build a clean record when something like this starts, leave it in the comments. And if you want more long-form stories where the outcome turns on procedure instead of volume, you can subscribe.